Okay, I think we'll get started. We still have some folks joining us, but I wanted to start with some background information about CARI and the series, and of course, welcome everyone to our webinar today. And this webinar is the fourth in a series that CARI has planned and presented on the enrollment and redetermination process of community health choices, which is Pennsylvania's Medicaid managed care program, and with the focus on the long-term services and support side. And we started off with a discussion about financial eligibility. We then had speakers from Maximus who talked about the independent enrollment broker and their role. And at the last session was about the functional eligibility determination process. So there are two key components to enrollment and redetermination, which are both financial eligibility as well as clinical eligibility. It's a very complex process, as anyone who's been involved with it knows. And today we are concluding this particular series on the grievance and appeals process. And we've also expanded while we're on this topic to go beyond simply the eligibility and redetermination process to also talk about other ways, the important use of the grievance and appeal system and community health choices for services like personal assistance services. So we'll be expanding our discussion in that regard. I wanted to mention, CARI, we're still operating during COVID, and we can be reached at 1-800-356-3606 or through our website. And you'll see Mario Lorenz, but that's actually David Johnson, who's CARI's Community Health Choices advocate. And he can be reached with any kind of question or concern you have in regard to if you're helping a client or you have a question around community health choices. And David's providing the technical support for today. So this is the first webinar you've joined, I want to talk a little bit about how the flow will go. I'll shortly be introducing our two great panelists for today, and they will give their presentation. And I know there's always questions, and it's in the chat box. Everyone that's registered will get an archive of the recording as well as the slides. You can find all but one of the webinars on our series, because we could not get permission to record that on our CARI CHC webpage, but you will get that information. So after their presentation concludes, I want to encourage you to put your questions in the chat box or the Q&A box all along the way, and we will take all your questions at the end, and you will be called upon to ask your own question. I will call two names at a time. So the first name will, you'll unmute yourself and ask your question, and then the next person will know you're next in line. And so we'll proceed in that fashion. So, with that, I want to David's going to put up a quick poll so we can get a sense of who our audience is today. So David, if you can put that poll up, and you could take a quick minute to make a selection from that list. And David will be posting the results of that in a minute. So I'll give you a chance to do that. Okay, David, are you able to post the results? Okay, so it looks like we have lots of folks that are working at one of the three community health choices managed care organizations. We have thank you for our volunteers that have been on all these calls. We really appreciate your service, and a consumer there, and we're glad to help you, of course, if you need any assistance, and some other folks. So thank you. So with that, I'm going to introduce our two speakers. We have two Pams today. And we have Pam Walls, who we've had the privilege of to work with for many years. I've lost track, Pam. And Pam Walls is a supervising attorney at Community Legal Services Health and Independence Unit in Philadelphia. And she represents older adults and people with disabilities regarding community health choices advocacy for residents in nursing facilities, personal care homes, guardianship concerns, any number of issues. And we also, our other Pam is Pam Putnam Silver, who's a staff attorney at Pennsylvania Health Law Project, which is a statewide organization. And Pam Silver focuses on improving access to older adults and people with disabilities for the Medicaid, again, services in community health choices. So with that, I'm going to turn it over to the Pams and let you begin your presentations. Thank you so much and for helping us today.
Glad to join you. So hi everyone, I'm Pam Silver. I'm from the Pennsylvania Health Law Project. Can we get the next slide? So just, Kathy told you a little bit about the PHLP. So we're a statewide nonprofit legal organization that provides legal services and tries to promote access to health coverage statewide. So some of the services we offer, can I get next? So we have our helpline for clients and advocates, which is open several days a week. And so we can do intake, give advice. We offer free legal services, which can include assistance with some of the appeals we're going to talk about today. We do all kinds of community education and training, just like we're doing here today. We have our monthly email newsletters where we write up about any updates affecting the Medicaid program in Pennsylvania. And we also do some policy advocacy. We work closely with with the Office of Long-Term Living and some of the other agencies that supervise the Medicaid program in Pennsylvania to help them with their efforts to monitor these programs and make the best use of them for participants. So I think at the end of this presentation, our helpline and our contact information will be posted. So yeah, we're here as a resource.
Hi, I'm Pam Walls, and I am an attorney from Community Legal Services in Philadelphia. I just want to say a word before we begin about Community Legal Services. We are a legal services organization. Here in Philadelphia, we provide free legal advice and representation to low-income residents of Philadelphia. We have many units, and so we have units that handle housing issues, including mortgage foreclosures, property tax problems. We have a landlord-tenant unit, a utilities unit that helps represents people whose utilities have been shut off, an employment law unit, a unit that handles debt and consumer right issues, a family advocacy unit, and finally the unit that I'm in, which is called the Health and Independence Unit. And we handle a range of different issues connected mostly to public benefits, including all the different kinds of community health choices appeals that we'll be talking about today, as well as Medicaid generally. We also represent people who have been denied or are being terminated from, or otherwise are having problems with SNAP benefits, SSI, Social Security, TANF cash assistance, LIHEAP, and just a range of different public benefits issues. Our unit also provides representation for nursing home residents, especially around residents' rights issues, and also for personal care home residents. In addition to representing individual clients, CLS also, like PHLP, does policy advocacy and community education. We have 2 offices in Philadelphia, one in Center City at 1424 Chestnut Street and the other at Broad and Erie at 1410 West Erie. Right now, during COVID, our offices are closed, but we're all working from home. And so we don't have walk-in intake as we normally would, but we are accepting cases, and the way to do intake is through telephone intake. And either of the 2 phone numbers on your screen are good to call for intake, and the person would just choose the prompt for the unit that corresponds to the problem they're having, and they can leave a voicemail message which will be returned so that they can do telephone intake. Next screen. Okay, so what we're going to cover today are appeals concerning community health choices. And there are several different kinds of appeals that Pam and I are going to be talking about. First, we're going to talk about eligibility to get into the Community Health Choices program. And there are 2 different kinds of appeals that come up in the process of that. And those are clinical eligibility denials. So in other words, proving that the person needs the level of care necessary in order to qualify for community health choices. And the second is CHC financial eligibility denials, showing that the person is financially eligible for this Medicaid program and therefore can get community health choices. And then thirdly, Pam Silver is going to be talking about appeals concerning denials of services once the individual is in the community health choices program. Next slide. So we're going to start out by talking about eligibility appeals to get into or stay in the Community Health Choices program, to qualify for it. So basic thing to keep in mind is that CHC is a Medicaid program. And so to qualify for it, applicants and recipients have to meet the Medicaid eligibility criteria, and specifically the criteria to qualify for long-term services and supports paid for by Medicaid. And there are 2 different types of eligibility criteria at issue. The first is clinical eligibility, which means showing that the person has the level of disability and the need for assistance with daily activities that will qualify them to participate in the program. And the second is financial eligibility, showing that the person's income and resources are under the Medicaid limits for this program. And we'll talk about both of those in detail. When people apply for or are receiving CHC or any Medicaid benefit, if their applications are denied or they're on the program and their benefits are reduced or terminated, they have the right to receive a written notice from the welfare department and to file an appeal and have a fair hearing concerning that termination or denial of benefits. And that's the process that we're going to be talking about today. Next slide. So first, let's talk about clinical eligibility, which sometimes is also called functional eligibility. And this is the kind of eligibility to show that the person meets the level of care, needs the level of care required to participate in the long-term services and supports program. And in Pennsylvania, we call this level of care nursing facility clinically eligible, or NFCE for short. And this is the level of care that a person, it's supposed to mean the level of care for a person who needs the care provided in or by a nursing facility. Doesn't mean that the person has to go to a nursing facility. It just means that they need that level of care. Because we now have, and have for many years had, home and community-based services available, people who are nursing facility clinically eligible can also choose to receive those services in the community through the Community Health Choices program. So there's a definition for NFCE, and we'll talk about that in some detail in just a couple of moments. In order to determine whether people are NFCE, Pennsylvania uses a tool, which it calls the Functional Eligibility Determination Tool, or the FED. And this is a tool that asks a set of questions that's administered by AAA, Area Agency on Aging assessment workers, through an organization called Aging Well. And we're going to talk about in some detail about the FED as well. There was a prior, I know that the last webinar went into a lot of detail. In fact, was it pretty much entirely about the FED? So this is just going to be like a quick reminder about how the FED works in the context of these appeals. The FED is a tool through which these assessment workers ask questions of the applicant about their ability to perform daily activities and their need for help with specific activities, including bathing, dressing, walking, or otherwise moving around their home, transferring to and from a toilet, using the toilet, and eating. These are the activities that this tool focuses in on. The questions in the FED are actually a subset from the Inter-I home care assessment, which many of you may be familiar with. And the assessor asks the person if they need help in these areas, and if so, what level of help they need. Are they, ranging from independence to total dependence, and many levels in between? It also looks at whether the person uses a wheelchair, whether they're bedbound, how they manage their medications, and if they have incontinence issues. And it also looks, asks some questions and does some very brief testing to try to learn something about whether the person has a cognitive impairment, and whether they have any issues with disordered thinking or awareness or behavioral issues, such as wandering, physical abuse, verbal abuse, or socially inappropriate behavior. So we're going to talk in a little bit more detail about that FED tool in a minute. So as part of the clinical eligibility process, the FED tool is administered and to determine whether the person is considered NFCE. And then secondly, the applicant also has to get a form called a physician certification completed by their doctor, saying that the person meets the NFCE level of care. This is a form that's sent by Maximus, which runs the enrollment process to the person's doctor by fax. And it asks the doctor to complete information, including what the person's diagnoses are, other medical information. And then it asks them to choose one of a number of boxes, identifying the level of care that the person needs. And then finally, the physician has to sign it. This form has to be completed. It has to say that the person's NFCE in order for the person to be found clinically eligible. Next slide. All right, so let's talk a little bit about the definition of nursing facility clinically eligible. Pennsylvania defines NFCE as an individual who has an illness, injury, disability, or medical condition diagnosed by a physician, and as a result of that injury or illness or medical condition, the person requires care and services above the level of room and board, and a physician certifies that the individual is NFCE. That's that physician certification form that I just mentioned. And the care and services are either skilled nursing or rehab services as specified by the Medicare program at various places in the Medicare regulations, or health-related care and services that may not be as inherently complex as skilled nursing, but which are needed and provided on a regular basis in the context of a planned program of healthcare and management, and were previously available only through institutional facilities. So this is a long definition. We can talk a little bit about where it came from. But one thing to remember is it's important to remember that this is the definition for NFCE. The FED is just a tool that's intended to determine whether this definition is met. So at a hearing, the ultimate question really should be, does the person meet this definition of NFCE? So if a person isn't able to show that they are NFCE using the FED, like if they can't be scored in such a way that they're going to be found NFCE on the FED, a good argument, the argument that the person should make is that they nevertheless meet this definition for NFCE, and this is the definition that should prevail. So this long definition actually comes from two other definitions, which are a definition in the state regulations that defines what used to be called intermediate level care, and the federal regulation that defines who's eligible for Medicare coverage of skilled nursing level of care. Next slide. Okay. So although that's the definition, Pennsylvania has developed and uses this tool called the FED to determine who meets it. So this tool is supposed to result in decisions that people who meet that definition are NFCE, and those who aren't don't. This is a document that has a subset of questions from the Inter-I home care tool, and it goes through a number of questions, including questions about cognition, behavior, performance of activities of daily living, which is the page that you see here, ability to self-administer, ability to manage medications, and incontinence. So if you look at this page here, you can see a little bit of how this tool works. It goes through the sort of the key activities of daily living that the tool looks at: bathing, personal hygiene, dressing, walking, locomotion, toilet use, and eating. And for each of these activities, the assessor is supposed to ask how the person performs that activity, whether they need assistance with it. And if so, the assessor has to rate what level of assistance the person needs. And if you look near the top under number 1, you can see that there are a number of scores from 0 to 8, defining the different levels of care, from independence, independent setup help only, supervision needed, limited assistance, extensive assistance, maximal assistance, and total dependence. And then finally, that the activity hadn't occurred during the prior 3-day period. So the assessor is responsible for determining, from interviewing the person and also talking with their family or caregivers if they're present. And in some cases, if there's some question, and it's during an in-person interview, asking for some demonstration, if that's appropriate, to determine what level of assistance the person needs. The assessor then rates it for each thing. So for bathing, they would ask the person how they perform it, and then they would rate them as either being independent or somewhere on that scale between independent and total dependence. The way that the FED works is that it asks the person how they performed these activities in the prior 3 days. It's called the 3-day look back period. And this is a characteristic of this tool that we advocates find very problematic. It asks how the person performed these tasks in the prior 3 days. A problem comes in if the person either has not performed that activity in the prior 3 days. They essentially don't get a score for it. It's just rated as not having occurred, which does not contribute anything to the finding of whether or not the person's NFCE. And in some cases, people may not have bathed, for instance, because they didn't have any help. They're applying for this program because they need help, and they may not have had assistance. And if so, they may not have performed these activities, or they may have struggled through it themselves, but really needed assistance. And so this is a concern. Our understanding from having discussed this issue with the department is that if the person hasn't done it in the prior 3 days, because they needed assistance, that they're supposed to be rated according to the assistance that they need, not as it not having occurred. So the assessor, after the assessor completes all the pages of the FED, which is a process that should take approximately half an hour, then the completed responses are scored by the tool itself using something of an algorithm that creates a score that determines whether the person is considered NFCE or not. And to do that, the department uses something which it calls the Fed tool translation matrix. Next slide. And this is the Fed tool, back one. Yeah. This is the Fed tool translation matrix. And I'm just gonna speak about it briefly because there was a lot of discussion in detail, I believe, about it on the last webinar. This is a key that basically scores the Fed tool. And in order to read it, the first row along the top contains all of the items from the Fed that get scored. So for instance, if you look under E, you'll see bathing, personal hygiene, dressing. That's from the page of the Fed that we were just looking at. And so these activities along the first row along the top are all of the activities that count from the Fed. The other questions in the tool actually don't count at all. These are the ones that actually get scored. The column down the left-hand side has all the possible scores that an applicant could get on these activities in terms of how much assistance they need. And it's again scored from 0 to 6, from independent to total dependence, or that the activity didn't occur. And then in the box below each item, it says what scores count as either what's called a partial deficit or a full deficit. So if you score a 2 to a 4 on cognitive skills for daily decision making, that's considered to be a partial deficit. If you score a 5, it's considered a full deficit, and so on throughout all the different activities. And in order to be found NFCE, the applicant must have either 3 partial deficits or 1 full deficit. And you can see that at the bottom of the page, it says that. In order to figure out for a particular person how their Fed was scored, you need to go back to their Fed results, which you can get from Maximus, and we'll talk about that, to see what score they received on each of these items in the Fed. And then you have to compare it to the translation matrix to see how many of them gave the person either a partial deficit or a full deficit in order to figure out whether the person is NFCE or not. One problem I'll just mention that I know Kate mentioned when she did this training before is that the printed out version of the Fed that you receive from Maximus doesn't actually have the numbers 0 through 6 that correspond to the level of impairment. Instead, it'll just say independent. It won't say 0, it'll say independent. And so you need to go back to an original copy of the Fed tool, which was distributed after the last webinar, and which we can send again today to participants to look and see for each activity what the number is that corresponds to the level of impairment. David, if you could just go back 1 slide, I'll point that out. So if you look here in section D, you can see 0 corresponds to independence. 2 corresponds to supervision. The problem with the printed out copy of the Fed that people get is it just says independent or supervision. You don't know if that's a 0 or 1 or a 2 or a what. And so getting a copy of an original blank Fed is really helpful just to go back and figure out what number corresponds to the level of impairment the person was scored at using the Fed. Okay, next slide. And next slide. Okay. So if the person is found nursing facility clinically eligible using the Fed process, the next step is that the process proceeds to the enrollment process goes on to the financial eligibility determination process, which is done by the county assistance office at the welfare department. If the person is found, if the person's not found NFCE, they're found what's called nursing facility ineligible, or NFI. It's kind of the opposite of NFCE. If they're found NFI, the welfare department issues a denial notice. It comes from the Office of the Long-Term Living, and it's a fairly lengthy notice, and it includes an explanation of the person's appeal rights and how to appeal. It also contains the definition of nursing facility clinically eligible, and should have some explanation, and will have some explanation of the process through which the person, the person's gone through with the Fed, and an explanation of how the person was determined not to be eligible. In some cases, the Fed and the physician certification may come out differently. So a doctor, for instance, may check off that the person's NFCE, but the Fed may come back NFI, or the reverse. The Fed may say that the person's NFCE, but the doctor may check off that the person doesn't need nursing facility level of care. In this situation, the Office of Long-Term Living has a medical director who reviews those cases and makes a decision about whether the person's NFCE or not. Next slide. All right, so let's talk a little bit about clinical eligibility appeals. When the person gets the denial notice, it has an appeal form included with instructions about information that needs to be filled out. The person should then send it to this address, which is on the notice. It goes to the Pennsylvania Independent Enrollment Broker, which is Maximus, at this address in Harrisburg. And it has to be postmarked or hand-delivered within 30 days of the notice date. In some cases, people may receive one of these clinical eligibility denials when they are already receiving CHC benefits. They may be going along receiving CHC benefits, and then there may be a new determination that they don't meet the clinical eligibility criteria, and they will receive one of these notices saying that they're not eligible because they don't meet the clinical, they're not NFCE. If so, they have the right to appeal. And if they appeal within 10 days, they have the right to continue receiving benefits pending a decision on their appeal. It's a really important right that we call aid paid pending, meaning you have the right to continue to get your benefits paid pending a decision on your appeal. So that 10-day deadline is really important to keep in mind, and to get your appeal in by if it's a notice that's terminating someone's benefits or reducing benefits in some way. Otherwise, the deadline is 30 days. People have the right to have a telephone hearing or a face-to-face hearing. And in cases where the person, we're waiting the 60 to 90 days it may take to get a hearing decision may place the person's health or life at risk. They can request an expedited decision. There's a place on it to do it, and the appeal will be held much more, will be decided and the hearing held much more quickly. Next slide. So when we represent clients in these appeals, and we do, we file appeals, or sometimes our clients have already appealed them when they come to us. We try wherever we can to resolve appeals prior to a hearing. And often, in most cases, we're able to do that. So let's talk a little bit about how to do that. The first thing you want to do is figure out what's the issue. Why did this person get found not clinically eligible? And the way to do that is to look at the notice, which will say whether the issue is that the person was found NFI on the Fed, or whether the issue is a physician certification. And you can also ask Maximus to provide for you a copy or what the issue was, and to provide the documents. In order to do that, you're going to need a HIPAA form signed by the client. You submit it to Maximus, and the person can get a copy of their Fed or their physician certification. The issue is usually the Fed. But if the issues, if the denials due to the physician certification not being submitted, then what you want to do is ask the doctor to provide it. Sometimes, doctors get a lot of forms they're asked to sign, and so sometimes they don't return it. And so the thing that needs to happen there is to get the doctor to turn in the form. In some cases, doctors have checked off a box that says the person needs a different level of care besides NFCE. And in that situation, you can talk to the doctor and see why they did that, whether they would reconsider. we had a case just recently where the doctor just didn't understand the definitions, checked off the wrong box in error, and corrected that. And so sometimes you can resolve an issue that way. Next slide. If the issue is that the Fed determination was NFI, you're going to want to see the Fed. And so you can request a copy from Maximus with a HIPAA release. You're going to want to review it and see what deficits the person was found to have, and then talk to the consumer and compare it to their needs. So you're going to want to look at the Fed and see what it said about the person's need for help with the various ADLs, and then ask the consumer, what help do you need with bathing, with dressing, and compare what they tell you to what is assessed on the Fed to see if there are places where the Fed is inaccurate, or perhaps something has changed since the Fed was done. What we often then do is if the Fed really seems to be at odds with what the client is telling us their needs are, one thing that we do in appropriate cases is to ask the Office of Long-Term Living to order a new Fed. And we do this if the Fed either missed significant issues, or if the person has experienced a change in their condition, especially in a deterioration since the Fed was done, or in some cases there were just problems with how the Fed was administered. We've seen cases where there was no interpreter provided, so communication was a problem, or in other cases, people really needed family members to be able to participate, to provide information, perhaps because the person had a cognitive impairment, or a traumatic brain injury, and that person wasn't able to participate. In other cases, we've heard of Feds that were done in like 10 minutes, where the assessor seemed to be really rushed, and the participant says that they really didn't have an opportunity to describe much about their needs. So in all of these cases, it's a good idea to consider asking the Office of Long-Term Living to do a new Fed to more accurately assess the level of the person's needs. And that can, in some cases, end up resulting in a determination that the person is NFCE, which will resolve the appeal and result in the person being found clinically eligible. Next slide. So if you can't resolve the appeal, the person is entitled to a hearing, which is held by the Bureau of Hearings and Appeals. These are called fair hearings. And the department sends witnesses to present their case. And the people who are sent are the assessment worker or a supervisor, and they come and describe how they assess the Fed, and how the Fed scoring process works. And I should just say, in all fairness, the Fed is relatively new, and we have not had many fair hearings, or perhaps any, go all the way through yet. So I'm going to describe how a fair hearing works. I can't actually say I've done one with the Fed. There's a tendency for these either to get resolved with a new Fed, or through at a pre-hearing conference. Sometimes the department will end up agreeing to do a new assessment once they hear the argument that the consumer is planning to make. So to prepare, so first of all, let's maybe just talk about a pre-hearing conference. At the beginning of a fair hearing, the administrative law judge who holds the hearing will begin by asking the parties, being the consumer on the one hand and the representative of the department on the other, whether they've had the opportunity to have a conference to discuss the issue that's under appeal, to see whether a resolution can be worked out. And if you haven't had one previously, you can, the judge will allow the parties some time at that time to do it. And you can, explain what the argument is that you're going to make, why you think that the Fed got it wrong, or that the person is otherwise clinically eligible for this program and needs it. And what in my experience, what often happens at that point is that the witnesses for the department will say, well, that wasn't said at the Fed. We didn't know that. If that's the case, maybe we should do a new Fed. And often that's what ends up happening, is we agree that to allow them to do a new assessment. And at that assessment, the consumer fully describes all of their needs, and if they need a family member there to help them with it, the family member's there, and that has, in many cases for us, resulted in the person being found eligible. So that's the way that's been my experience with these fair hearings. But if a hearing is held, first of all, to prepare, what you'll want to do is request relevant medical records. So you want to get medical records as much as you can from the medical providers to show what the person's medical conditions are that are relevant to their need for the services, and a letter, if you can get a letter from the doctor describing their functional limitations and the need for LTSS, that's really helpful. At the hearing, the department presents their case, meaning that the Aging Well assessment worker or their supervisor describes how the Fed was done, what the outcome is, explains just how the Fed works, and explains why they found that the person was not clinically eligible. The consumer, their representative, then has the opportunity to cross-examine the department's witnesses and ask them questions. So they might want to ask questions about functional impairments that were missed or other problems with the Fed process. And then the consumer or their representative then has the right to, then presents their case. And what you would want to do in that situation is to focus on the person's needs, to argue their that what the functional impairments are that the person has that were not picked up in the Fed, and that should have been, and how had they been picked up, the person would have had 3 partials or a full deficit and would have been eligible. And another argument that the person can make is that they meet the definition for nursing facility clinically eligible. In the past, I've gotten letters from doctors, or even had doctors call in and testify that the person's condition meets that description. And ALJs have deferred to that opinion in some of our cases. And the other thing that you can do is argue that the Fed was defective in one way or another. And the judge will then render a decision which could find that the person is NFCE, that they've met that burden of showing that they actually do have 3 partial deficits or a full deficit, or that they do meet the definition of NFCE. The other thing that the judge could do is make a finding that the Fed was done in a way that's inadequate, and order a new assessment to be done at that point. And yet these decisions are decided by administrative law judges, sometimes called ALJs. Next slide. After the hearing, the administrative law judge sends a written decision with their decision to the consumer. If it's not favorable, there are further appeal rights. The consumer can request file what's called a request for reconsideration with the Secretary of the Department of Human Services within 15 days. These are usually letters arguing why the hearing decision was legally incorrect, or that the findings made by the judge were not supported by the evidence. And the person also has the right to appeal to Commonwealth Court. And if they want to do that, they have to do it within 30 days of the hearing decision, or denial of if the person's requested reconsideration within 30 days after that was denied. Next slide. Okay, now I'm going to talk about the other kind of appeal that comes up in trying to get into the Community Health Choices program, and that's financial eligibility. So to qualify for Medicaid, as everybody knows, you have to meet the income and the resource limits. And So the income limit for this particular program for a single person is $2,349 a month. That number comes from 3 times the federal SSI rate. This year, that's $783. So 3 times that is this number. In applying for these programs, only the applicant's income is considered. Their spouse's income is not considered. So it's a fairly high income level. We do see some people whose income is over that limit. And in some cases, there may be a way to help the person qualify through setting up what's called an income-only special needs trust, which is a kind of a trust, a special needs trust, where the person can send the income that exceeds the limit, the income limit each month to the trust. And then that money has to be used for medical expenses that are not covered by Medicaid. To do this, you need an attorney. And I think sort of the takeaway from this is just to remember that there is a possible process for people whose income's over the limit, but it's going to require a referral to legal services or to a private attorney who specializes in this. There's also a resource limit, which is $2,000 plus there's a $6,000 resource disregard. So $6,000 of resources aren't counted. So what that means in essence is that the resource limit is really $8,000 for a single person. For married couples, the spouse who is not receiving benefits is allowed to keep a certain amount of the couple's combined resources to prevent them from being impoverished. And so there's a calculation that's done. There's federal law called the Federal Spousal Impoverishment Rules. In determining resource eligibility for a married couple, the resources of both spouses are considered. However, the spouse who is not applying is allowed to keep a certain amount of resources. The sort of the broad rule is that the non-applicant spouse can keep half of the combined countable resources, subject to a minimum and a maximum. And the non-applicant spouse's retirement accounts don't count. So if you have a married couple and there are issues around resource eligibility, this is a good kind of case to refer to legal services if there are if there are any difficulties with qualifying. Resources are the assets that what the person owns, and so it includes savings accounts, accounts of any kind. The home that the primary residence that the couple lives in does not count, but any second properties do. Cash value of life insurance counts as a resource. And various other kinds of resources count, but the non-applicant spouse's retirement accounts don't count. Next slide. So the County Assistance Office makes a determination about financial eligibility, and they send out a notice when they do, with appeal rights. It's important to distinguish between initial denials and termination notices that people receive. When a person first applies, if they're found not eligible, they're going to get a denial notice. If a person's already in the program and they get cut off, they get a termination notice. And these notices are often issued after redeterminations, which is the process through which annually people who are in the Community Health Choices Program have their financial eligibility redetermined. And a problem that we often see are people who are have gotten the redetermination forms in the mail and either didn't return them, maybe were confused by them, or weren't able to gather up the verification, or they did get them, they did complete them, they mailed them back, and the County Assistance Office lost them. This is a kind of appeal that we see periodically, people who are getting cut off at redetermination because they didn't get through that redetermination process successfully. Our hope is that service coordinators at the Community Health Choices plans are going to be helping people with that process, because it can be really very difficult for especially frail older people or people with cognitive impairments to complete those forms, understand their significance, gather bank statements, and get that back in. So people really need support with that. When the county assistance office finds someone not eligible, they issue a denial notice, which is called a PA 162. That's the number for the form. What needs to happen at that situation when that happens is to file an appeal. To do that, you complete the appeal section of the notice and send it to the county assistance office. When you do, and when you do that, you want to be sure to keep a copy and keep proof that it was filed timely. You can do that by sending it certified mail, return receipt requested, or if you have an email contact there, you can send it by email, but you want to keep the email as proof. Or if the person walks it in, they want to be sure to get a receipt from the county assistance office, because often documents, including appeals, are lost. And it's important to be able to prove that the person appealed timely so that they can pursue their appeal rights. There are 30 days to file an appeal for a Medicaid decision. And again, if it's a termination, you want to do it by the aid paid pending deadline, which will be on the notice. And for these notices, it's usually about 15 days from the date of the notice. You want to check the notice to check when it is and make sure that the appeal is filed before that date, to make sure that they can keep getting their benefits while they wait for the hearing to be decided. Next slide. Another way that people can, if they've received a notice saying that they're not eligible or their benefits are being closed, another way of resolving this is through the reconsideration process. The county assistance office will reconsider a denial of an application or a termination if the person asks them to and submits the required verification that was missing within 60 days of the date that the application was denied or the benefits were closed. So let's say a person gets a notice saying, we're denying your application because we requested copies of your bank statements. You did not submit them. Therefore, we're denying your application. And this happens all the time. Person has the right to appeal that within 30 days, and they should do that to make sure that they have the right to go through that process. But if they submit whatever that verification is that was missing within 60 days of the date of the denial or the date that their benefits were closed, and ask the county assistance office to reconsider that decision, county assistance office will review those bank statements or whatever it is that were sent in, look at the case again, see if that's enough, if that establishes the person's eligibility, and if so, they will reopen the case without the need for a new application and without the need to go through the appeal process. Similarly, if a person is on community health choices and their benefits are closed because they don't get through the renewal process successfully, and when I say renewal, same as redetermination, that annual process through which the county assistance office looks to see if the person continues to be financially eligible. If the person doesn't send the forms in, or the forms get lost, or some verifications not provided, and the person's benefits are closed, again, if the person then gets the verification that's needed and the forms completed that are needed and submits them within, in this case, 90 days of benefit closure, the county assistance office will review that and determine whether that's sufficient to establish the person's eligibility. And if so, they will reopen the case without the need for a new application or to go through the appeals process. This is a really important, yeah.
And Pam, can I just add something here?
Yes.
So I just want to add how important this reconsideration window is, because if you wait until too long after the benefits have been closed, they may have to start over the entire waiver application process again. And so, this allows you to go this makes it much quicker. The other thing I just wanted to flag, just previewing what Pam's going to get to in a few slides, is that This reconsideration we're talking about here is different than asking the secretary for reconsideration of a fair hearing decision. So we're throwing a lot of reconsideration out there. Just keep in mind that this is different than asking the secretary for reconsideration.
Thank you. Those are really, really great points. Next slide. All right. So in financial eligibility appeals, very often the issue is verification, the process of submitting proof of the person's financial status to prove that they're under the income limit or more often the resource limit. We try, it's a really good idea to try to resolve these prior to a hearing. It's faster, gives you extra opportunities to be successful at it. And so this is what we always do, and we encourage everyone to do this, is to get in contact with the county assistance office, find out from talking to them and from the notice what was missing, what verification wasn't submitted, and submit it now. And ask the county assistance office to consider it and determine whether it's enough to determine the person eligible. So often this is going to be about bank statements, proof of the cash value of life insurance, other kinds of accounts like that. A few things to keep in mind in this process. First of all, just be aware the county assistance office has the ability to check the monthly balance, to look through something called the automated verification system, which is an electronic system to look at people's bank balances from many banks. So they can actually look and see, where does the person have accounts, and they can see the balance at the beginning of the month for a period going back years. And so a lot of this information that they ask consumers for, they actually already have access to a lot of it. So something to keep in mind, and we'll talk about why in a moment. When people are first applying for community health choices, the department is required to do what's called a look back review. And so the Medicaid rules provide that you can't qualify for long-term services and supports if you've given away anything of value in the prior 5 years. The concern that Congress had in creating these rules was that people would give away their life savings or their homes to their children in order to qualify for Medicaid-funded long-term services. To keep people from doing this, they require the welfare department to look and see, did people give away assets? There are some exceptions to these rules. There are some places in which there's some exceptions where it's permissible to give things away. But the welfare department's required to look and see if people have given away anything of value in the prior 5 years. And if so, they then have a process through which they may find them ineligible for a period of time. So to this end, the welfare department requests from people bank statements. The way it's often communicated to applicants is that we need 5 years of bank statements. In fact, they don't really need 5 full years. They're looking back 5 years. What they actually ask for, or should ask for, is the prior 2 years of bank statements. So all your bank statements for the prior 2 years, which is already a lot, plus 2 statements from each of the prior 3 years that are 6 months apart. So for the 3 prior years, either January and June or July and December, to give sort of a snapshot of how much money was in the person's account at that time, to give the welfare department an idea of, you pretty much just had your Social Security, or you had, a very stable amount of money. It doesn't look like you were giving anything away. Or to look and say, oh, you had a lot of money at that point. We're going to look into this and see what happened to that money. So in this process, the county assistance office asks people, first of all, they often ask them for 5 years. So one thing to take away from this is it's not really 5 years, it's 2 years plus a couple of bank statements from the prior 3 years. This is a real problem for applicants. It can be very expensive. Logistically, it's really hard. A lot of our clients can't go online and print this out. It's a real big problem. And we've done some advocacy around this to try to get the department to be to make this more manageable for people who are applying. The department has issued a policy clarification, and there's information about it in the fourth bullet point here, which is available on the department's, in one of the departments, in the department's long-term care handbook. What it says is if the applicant is not able to provide bank statements going back 5 years, like verification of all their resources during this 5-year look-back period, and on their application, they didn't indicate that they gave away any assets. And if looking at this automated verification system, which again is this electronic system where the county assistance office can look to see people's bank statements, if this doesn't show that there are bank statements that the person's hasn't disclosed, or large balances that create questions. In this situation, where if the person's saying, look, I can't get you 5 years worth of bank statements, it's just too expensive, the county assistance office will authorize benefits. If the person submits at least one or as many bank statements as they can so that they can see that the person's currently eligible. So this is really important to keep in mind for many, many people who get hung up on this problem of bank statements. You also keep in mind that you can ask the county assistance office to check it themselves through what's called a collateral contact. The county assistance office can have the applicant sign a release form called a PA4, and at that point, the county assistance office can request the records themselves. But that takes some time. Much better to get the county assistance office to agree to authorize benefits because the person simply can't get these bank statements. The last thing I want to talk about in connection with this is Direct Express. Direct Express is a debit card product that a lot of SSI recipients and some people on Social Security have. It's a debit card that people receive that their SSI or Social Security benefits are paid directly into. People cannot put other sources of funds onto these accounts. It's just got your SSI benefits on it is all. There have been a lot of problems with the welfare department wanting statements from Direct Express showing people's balances over the past 5 years or showing the balance at all. And the reality is that Direct Express is not a place that you can deal with easily. You can't, it's very difficult to get through to them, very difficult to get anything from them in writing. And in recognition of this, the department has issued another policy clarification that says if the person says they can't verify the balance of their Direct Express account, the county assistance office will just take the balance that the person said that they had on their application. And so this is really, because it's so difficult to get verification from Direct Express, in the county assistance office should just be accepting the balance listed on the application. So again, verification is often what's going on here. And this is the kind of thing, if you get the verification, get it in, these things can often be resolved. For more complicated financial eligibility problems, it's a good idea to refer the person to legal services or a private attorney.
And I just wanted to add one other scenario that we've seen, is that like the participant or the applicant is having difficulty getting resources or verifying shared resources. Either the resources belong to an estranged spouse, or they were shared with an ex-partner, or there's domestic violence situation, but for whatever reason, they're not able to get verification of these resources. Just be aware that there may be a workaround process for that. If you can provide explanation of those special circumstances to the county assistance office, they can usually find a way to proceed with the application without considering those resources, but they need to know about the circumstances.
Thanks. Next slide. All right, so in many cases we can resolve these issues before going to a hearing. But if you do have a hearing, it's called a fair hearing. Again, it's held by the Bureau of Hearings and Appeals. Just like the clinical eligibility denials, there's an opportunity for a pre-hearing conference. particularly if you have a pre-hearing conference, you can often talk to the caseworker about what the remaining issue is. And sometimes you run into a situation where they needed bank statements or they needed proof of life insurance, and you just can't quite get it before the hearing. In that situation, you can enter into, you can talk at the pre-hearing conference with the caseworker about that situation. And you can often get them to agree that if you provide that verification by a certain date, you can often get them to agree to enter into a stipulation with you, basically an agreement with you at the hearing, where you are agreeing, I will get you these documents that you need, county assistance office, by a certain date. And the county assistance office in turn agrees, okay, if you get us those documents, we will review them and we will we will make a new determination about whether the person is eligible. And we will issue a new notice which you can appeal if you disagree. This is a great way to resolve financial eligibility appeals where you're not able to gather all of the documents prior to the hearing, which, because there's so much verification needed, and it's often so difficult for these clients to gather stuff, this comes up actually quite a lot. And so this is a great way to get some additional time to get the documents in that you need, get the welfare department to consider them, and hopefully make a new and favorable decision. Next slide. What happens at a fair hearing? So what happens is that the county assistance office sends a caseworker who presents their case, basically explaining here's the action we took, here's the reason that we took it, and they present the supporting documentation and evidence. The consumer and their representative has the opportunity to cross-examine and ask questions of the department's witness. And then after that, the consumer gets to present their own case and argue why they believe that they're eligible, and they can offer exhibits and evidence to prove that. The administrative law judge makes a decision, issues a written decision, and again, as with the clinical eligibility appeals, if the ALJ's decision is unfavorable, the applicant has the right to request reconsideration to the Secretary of Department of Human Services within 15 days, and they also have the right to appeal to Commonwealth Court within 30 days of the hearing decision or the denial by the Secretary of the request for reconsideration. Okay. Next slide. That's it for my slides.
Yeah, thanks, Pam. So the next type of appeal, or the next type of a decision a person might want to appeal once they've been accepted into community health choices, is they might encounter a situation where the CHC plan, the managed care organization, or MCO, denies a particular service. So once they're in community health choices, they have a right to appeal any sort of adverse benefit determination that comes up. This might include, a denial or reduction or suspension or termination of a service based on medical necessity. These are the ones we see most often. But it could also include a failure to provide services in a timely manner or other situations. So next slide. So as with the clinical eligibility or financial eligibility denial, the participant is required to get a notice. In the case of a service denial, the denial notice is going to come from the MCO, the CHC plan. They are required to issue a written denial notice. A phone call from the service coordinator is not notice. For I think all three CHC plans, their common practice is to try and have the service coordinators give the participant a phone call just to give them a heads up about a reduction and make sure they understand their appeal rights, and basically give them the heads up that a denial notice is coming in the mail. That'll give them more details. But it's important to realize that they're still supposed to get a written notice. The participant doesn't have to wait for the notice to appeal. I mean, as soon as they hear from their service coordinator that there's a reduction, they can call their plan and immediately request an appeal. So they don't have to wait for the written decision. One thing we've heard some service coordinators tell people is just wait for the denial notice to file your appeal. They don't have to, and in a lot of cases they shouldn't. And I'll explain why in a second. The other thing to notice is, as with the termination notices, for a reduction or denial of an ongoing service, such as a reduction in personal assistance services or home care hours, the notice has to go out at least 10 days prior to the proposed action. They have to give this advance notice period. And why that's important is, next slide, is that the person has the right to continuing benefits or aid paid pending while they're waiting for the appeal. This means they have the right to keep their existing services, like, for example, their existing level of PAS, in place while the appeal is being decided. This is really only going to come to play in a case where the MCO is trying to reduce or change the services they're already getting. But in those cases, the participant really wants to appeal within 10 days of the denial notice or the effective date of the decision, whichever is later, in order to guarantee that they can keep their benefits in place while they're appealing. I will say that the denial notices aren't really clear on this middle point. Some of them will just say you have 10 days, like, in order to keep your current benefits, you have to appeal within 10 days of this notice. And they don't mention that it could be the effective date of the decision. So, for example, the notice might be dated October 1st. It says this decision will be effective October 15th. But then it says you have 10 days from this notice to appeal to keep your benefits going. And so it isn't clear to the participant that they actually have until the 15th. So just keep in mind 10 days or the effective date of the decision, whichever's later. I also just want to make it clear the participant can still appeal a reduction. They can still appeal after that 10 days. Their services will just be reduced while they're appealing, which isn't really a good position for a lot of people. But it's important that they have more than 10 days to appeal. It's just if they want to keep their current benefits in place during that process, they really need to appeal within 10 days. Next slide. So to give you just a overall look of the appeal process for service denials, you can see that they have the state fair hearing reconsideration process that Pam discussed, but because these decisions are coming from managed care companies, there's a couple other additional layers of appeal, including the grievance and external review. And so they all have their own timelines. So I'll be referring back to this slide, but I just wanted to give you the big picture that they have extra layers of appeals for service denials once they're in CHC. Next slide. So the first level of appeal is a grievance. And basically the grievance is more informal. It's basically you're asking the MCO to revisit their decision before you take it to a judge. And specifically it's asking them to reconsider a decision concerning medical necessity or appropriateness of the service. So an example might be the plan denies the request completely. So they deny your request for a specific power chair or a specific piece of equipment because it's not medically necessary. Or they approve services in a smaller amount, scope, or duration than requested. So this is the most common. The participant is requesting to continue 84 hours a week of personal assistance services, and the plan's only going to approve 60 hours a week. Or lastly, the plan might deny a requested service, but approve an alternate item of service. So say a participant requests a bathroom modification to make their bathroom accessible. They want a walk-in shower. The plan might deny that, but approves some other thing. Like, for example, we're denying a request for a walk-in shower, but we're approving a shower bench and grab bars. Next slide. So, whichever the reason for the grievance, who gets to request a grievance? So it can come from the participant, their power of attorney or legal guardian, or really anyone that the participant designates in writing. One issue that we've run into is how plans handle the situation where a grievance request is coming from the participant's family member, like a daughter or son or their parent on their behalf. But it's coming from a family member who doesn't technically have power of attorney or legal guardianship. And what one of the plans will do is they'll take the grievance and then they'll make efforts to follow up with the participant directly to get their consent to proceed with the grievance. But a lot of times the participant never hears from them. So sometimes this can delay the process of getting a grievance in. The other situation where this can be an issue is where the participant doesn't speak English or lacks the capacity to make their own request, but they don't have a power of attorney or legal guardian to do it. In these cases, we've advocated to allow the request to be made by a healthcare representative. So the Pennsylvania statutes lay out a process where, like a hierarchy of family members who can be appointed as a representative, where the individual lacks capacity. And so this can be a workaround in a case where there's no legal guardian. Or the participant can sign a form giving they can fill out the grievance request form, giving their family member permission to act as a representative. But I would say overall, the best practice would be, to have the participant on the phone with whoever's making the request, or if they have the paper form, to have the participant sign that form requesting the grievance. Next slide. So, in terms of the timing, as we said, you want to request the grievance within 10 days of the decision date or prior to that effective date in order to get continuing benefits. Otherwise, they have up to 60 days from the denial notice to request a grievance. And they can request a grievance in a few ways. They can do it by phone, fax, or by mail. When requesting it by phone, like I said within the previous slide, I think it's best practice to have the participant on the line to be able to, even if their family member is going to be doing most of the talking, so that the participant can give them permission to talk for them. We recommend documenting the date and the time you make that call and the person you speak with, so you have a record of when you requested the grievance. And it's also usually a good idea to send in a follow-up letter or the form, follow up in writing to confirm the grievance request. If you're sending it by fax, always keep that fax confirmation sheet if you can, so that you know when you sent it. And then you can also request it by mail. They'll send there's a form that they will send to just like a complaint or grievance request form. You can fill that out and mail that in and just make sure it gets postmarked by the deadline. We recommend sending it certified. It's not required, but it's good. We recommend mailing in some form that you can track it and know when you sent it and when it arrived. Next slide. So once you've requested your grievance, I think that an important thing to do when you're preparing is to know that the participant has the right to request documents related to their grievance. So in the Community Health Choices Agreement, it makes it very clear the participant has the right to review all relevant documentation pertaining to the subject of the grievance ahead of the grievance. So, you know, we recommend when you're making an initial grievance request, or when you get that first letter acknowledging that they got your grievance request, call the plan and request these documents. And in a PAS case, some of the documents that you're going to specifically want to request might be that the inter-RAI assessment or comprehensive needs assessment. This is the assessment that they do periodically to determine the amount of personal assistance services or other services. We also suggest asking for the Person-Centered Service Plan, or PCSP. This is the plan that kind of lays out all the needs that were identified in the inter-RAI and what services the plan is going to put in place to make that happen. The participants are already supposed to get a copy of this, but we find oftentimes that they don't. When you're getting ready for a grievance, though, it's good to have a look at it to make sure there's no inaccurate information. Another type of document you might want to request for grievance is any sort of time and task tools, or like they go by different names, but it's a, like, I think that's a personal services support tool or a service planning guide. They go by different names, but what they are is, it's basically a chart that either captures how much time the participant reports that they spend on certain things, or it's kind of a chart that takes their responses from the inter-RAI and spits out a suggested number of hours for different tasks. It's a good way of getting a breakdown of how the plan is assigning the hours for personal assistance cases, PAS cases. Participants should also ask for any sort of policy or medical necessity criteria related to the service at issue. It might just be the basic medical necessity definition, but for some things, like, for example, certain types of durable medical equipment or special equipment, the plans might have specific policy or prior authorization criteria for that. And really, any other documents, policies, medical records, communications reviewed in making that decision to deny or reduce services is something that they want to ask for. And like I said, the best time to ask for these is when you're making that initial grievance request. Point to the section. It says right in the denial notice that you have the right to request these. So you can point to that and ask right when you make the initial grievance request, so they have plenty of time to get it to you. Otherwise, you can request it any time between when you first ask for the grievance and when they schedule it. Next. So how does the grievance work once it's happening? So first of all, I should note that the participant's required to get a notice of the date and time of the grievance, or the plan is required to send out notice at least 10 days in advance with the date and time of the grievance. The participant might not get it until closer to the grievance, but the plan is supposed to send it out at least 10 days in advance. So there will be a grievance panel or committee that consists of 3 people who weren't involved in the initial decision. One will be a physician or medical director who is supposed to be in the same or a similar specialty as will typically manage or consult on the service at issue. One problem we've seen is occasionally that the medical director on the grievance panel will be a pediatrician. When the participant is an 80-year-old with dementia. And so those, usually we want to check what the physician's specialty is to see if it's relevant. The other 2 people on the panel will be an employee of the plan and a person who's not an employee of the plan. And then usually there'll be someone from the appeals department who's not voting, who's just there to facilitate. So the grievances, they can be in person, over the telephone, or by video conference if the participant requests it. They're generally informal. There's no, rules of evidence. There's no specific procedure they have to, there's no specific, procedures they have to follow to introduce their materials. It will be recorded or transcribed. And it's usually 30 to 60 minutes. And basically the participant basically has a chance to make their presentation, make their case, introduce any, present any witnesses or materials that support why they need the service or item in question. But it's an important opportunity for them to kind of state their case, but people shouldn't be going into this thinking that it's going to be as formal as a courtroom, because it's not. Next slide. So in terms of the timing of the grievance, the plan has to hold the grievance within 30 days of the person's grievance request. It can be extended an extra 2 weeks if the participant requests it. And then once the grievance has happened, the plan is supposed to issue a decision within 5 days. And if there's a representative, they're supposed to send a copy of that. So this would be a written decision explaining the outcome and and the reason for their outcome. If the MCO misses these deadlines, if they fail to adhere to these procedures, the timing, the participant is entitled to move past the grievance, and they can go directly to a state fair hearing or an external review. Next slide. I should also note that it's possible to expedite the grievance in cases where waiting the normal time frame would be harmful to the person's health. So this might be a situation where the person missed the 8-pay pending deadline, but it's a really drastic cut in services and it leaves them very unsafe. So if the person thinks that 30 days is not going to be fast enough, they can request an expedited grievance by submitting a letter from their provider, from a doctor, certifying that the member's life, health, or ability to attain, maintain, or regain maximum function would be jeopardized by following the regular appeals process. So this should be in writing. Once the physician certification is required in order to get this expedited. If the MCO decides to grant the expedited grievance, they'll hold it within 48 hours or within 48 hours of getting that provider's certification, or 72 hours of the original expedited grievance request, whichever is shorter. And then they're supposed to issue a decision within 2 business days. Next slide. Wait, can you go one slide back? Oh, okay. I guess so. I guess it was deleted. So, next slide. Okay, so if a participant loses at the grievance stage, they have 2 types of appeal they can pursue from there, and they can pursue them both simultaneously. So one option is what's called an external review. And this is a paper review by an outside physician outside of the CHC plan. These physicians are usually employed by what's called a CRE, a certified review entity, that is assigned by the Department of Health. And as with the medical director, it's supposed to be a physician in a same or similar specialty that typically manages the service being reviewed. And so Yeah, so the participant has 15 days from the grievance decision to request the external review. But if they want to get continuing benefits, they have to request it within 10 days. And they can request it by phone or in writing through the MCO. They just have to call the plan and say, hey, I got this grievance decision. I want to do external review. Next slide. So back to this framework. Ordinarily, you have to exhaust the grievance before you can go to external review or fair hearing. The only way you can get around the grievance is if the plan misses its deadlines for holding the grievance. That's in those cases you can claim deemed exhaustion and move ahead. All right, but so here you can see that for external review, it can be pursued at the same time as the fair hearing. And then if the external review is denied, you can appeal it to Commonwealth Court. Next. So how the external review works is the MCO has 5 days to notify the participant that they got the external review request. The Department of Health assigns a CRE and issues a notice to the participant with the CRE's contact information. At that point, the participant has 15 days to submit documentation and any additional materials they want to submit to the CRE. And we usually recommend that the participant take advantage of this. They should submit anything that they provided at the grievance and any additional documents, arguments, briefs they want the CRE to review. Don't assume that the MCO is going to send all the documents that were presented in the grievance. They're supposed to, but we find it's not always the case. And they also aren't necessarily providing a full transcript of everything that happened at the grievance. So it's important that the participant make sure that they provide anything that they want the CRE to review. And then they should also send copies to the MCO of whatever they sent to the CRE. On the other side, the MCO is supposed to send a list of any documents that it sent to the CRE. And they're supposed to send all documents related to the grievance, but the plans have defined that. The plans define that differently. So again, you can't assume that everything the participant sent to the plan for the grievance is going to make it to the CRE. Next slide. So the external review decision is going to be issued within 60 days of the request. There are ways to expedite that if needed. If the participant wins, the plan must approve and pay for the service, even if the MCO decides to appeal it later. And the participant or the plan can appeal to Commonwealth Court. This isn't going to go to a fair hearing. It'll go straight to Commonwealth Court if you're trying to appeal external review. Next slide. Okay, so the other appeal track that a participant can pursue after the grievance is to go straight to a fair hearing, which is the same fair hearing process that Pam described for both clinical and financial eligibility determinations. Next slide. So I just want to stress, sometimes the plans or the service coordinators will mistakenly tell participants that you should just wait for the external review to be done and then request a fair hearing. You can, but I don't recommend it. So they can and they should request a fair hearing at the same time as external review. They have to be requested separately. So because requesting external review within that 10-day window doesn't guarantee you continuing benefits through the end of the fair hearing process. If you want to pursue a fair hearing and get continuing benefits, you have to request it within 10 days of the grievance decision. not within 10 days of external review. So you should treat the external review and fair hearing separately. Requesting external review within 10 days gets you continuing benefits through the end of the external review. Requesting fair hearing within 10 days gets you continuing benefits or aid paid pending through the end of the fair hearing. But one situation we've sometimes seen is that the participant requests an external review within 10 days, gets continuing benefits, but waits to request the fair hearing. In that situation, their right to continuing benefits would end when they get the external review decision, which might come back before the fair hearing decision, in which case they may have their benefits shut off while they're waiting for the fair hearing. And if that doesn't make any sense, add a question into the comments and I can try and explain this again. So to request a fair hearing, we usually recommend using a form that comes with the grievance decision, or you can request it in a letter. But it needs to be in writing. They have 120 days from the grievance decision to request a fair hearing, but as with everything else, if they want to keep their benefits while they're waiting for the fair hearing, they have to do it within 10 days. Next slide. And then the written fair hearing decision, so the hearing will be scheduled and the decision should be issued within 90 days of the grievance request, minus any time spent between the grievance decision and the fair hearing request. So the time spent between when they request the grievance and when they get the grievance decision counts towards these 90 days. And if there's no decision within that 90-day clock, the participant has a right to what's called interim assistance, which means they can get the benefits while they're waiting for a final decision. Next slide. And then Pam mentioned this earlier in the context of clinical eligibility and financial eligibility, but the participant can request an expedited fair hearing if a physician certifies that their life, physical and mental health, or ability to attain, maintain, or regain maximum function would be placed in jeopardy by waiting that normal 90-day window for the fair hearing. In this situation, they will pretty quickly schedule like a mini hearing specifically on the issue of whether to expedite the grievance. And then if they decide to grant the expedited fair hearing, there will be a full hearing within 3 business days with a decision. And then I believe that's the last slide. Is there another slide? There we go. Questions. So at this time, we're happy to take any questions anybody has.
So this is Kathy again. I want to thank both Pams, and we tip our hats to you both for your presentations and your work in shepherding people through these processes. The stakes are high. We always encourage, and anyone that with this presentation would agree, that people should get connected with legal services. It's no cost, and people are always more successful with that kind of support through these complicated processes. So again, I thank you both. And I'm going to be calling on Loretta Dugan and Michelle Ramp. But before, as they're getting situated, I wanted to ask if either of you could address the current mail delays that many are experiencing. How, if that causes someone, let's say they thought, oh, gee, I got this after these dates. What do you recommend in those situations?
Sure. Do you want me to take this one, Pam?
Sure, go ahead.
Sure. So we've seen this quite a bit where like someone say they don't get the letter until after that 10-day window. So in this situation, we would usually recommend, first of all, that they keep the envelope with the postmark on it. You know, and check when it was mailed. If it was mailed like 2 days before they actually got it, if it was mailed significantly later than the date on the notice, they should point that out. But they should talk to the plan, explain the situation, explain that, look, this letter is dated September 29th, but I didn't get this notice until the 16th. I didn't get this notice until yesterday, and it says I only had 10 days to appeal. And they should specifically ask if they can still get the continuing benefits, or they can seek help for legal services, and we can help them reach out to the plans to resolve this issue. But that's a good question, and they definitely should bring it up. They shouldn't just take it, oh, well, I guess I missed a deadline. They should emphasize that they missed the deadline only because the mail was delayed. And in our experience over the last couple months, when this has come up, the plans have been very willing to grant the continuing benefits and just move ahead with the grievance process.
And similarly, if a notice from the welfare department arrives after the 10-day period, the person should do all of the same things Pam was just talking about in terms of keeping the envelope and taking a look at it. And they can also explain what happened and request that their benefits continue because they didn't receive the notice until the date that they received it, and argue that there was a mail delay. Good idea in that situation. That would be helpful to refer the person to legal services for help with that if they're having problems. The other thing I wanted to say is that we've seen sort of large-scale problems with mailing from the welfare department in the past year and a half. There have been a couple periods of time where there were just problems getting the mail out from DHS, and thousands of notices didn't go out when they were supposed to and were hugely delayed. We've been able to advocate on behalf of large numbers of people to get their rights protected in those situations. So if something like that happens again, good thing to refer to legal services if for individual people, or if there seems to be a pattern of it as well.
Thank you. Okay, Loretta, did you want to ask your questions, and then we'll be calling on Michelle Ramp?
Sure, I thank you so much. This is enormously helpful. And if I can, I'd like to ask two questions. One, when a participant is asking for increased hours of home health aid, many of our patients are coming to our office saying that they absolutely need a letter of medical necessity from the doctor. And my second question is, these home modifications, things like stair glides and stair lifts out front of the house, I find they're not denied, they're just delayed. It seems to drop through cracks, and I can never get clear information from service coordinators about their process and what exactly is needed, and it just gets delayed and delayed. So thank you.
Hi, Loretta, thanks for your question. So your first question had to deal with letters of medical necessity?
Yes.
So I don't know that a letter of medical necessity per se is required, but for purposes of helping to get the increase approved, or for purposes of appeal, a strong letter from the doctor can be very useful. And the letter shouldn't just say they need this many hours because, and then a laundry list of their health conditions. It really should go into detail about why they need the increase or why the existing hours should continue. Giving, like, for example, giving any reasons why, any consequences that might emerge if they don't get the increase. So I would recommend getting a strong letter of medical necessity. in terms of your question about, sorry, other Pam, do you have anything to add to that? Okay. And then in terms of your question about the delays in home modifications, we see this too. And I think, and we're, we as advocates are still working through how to make this process run smoother. I would go back to the initial slide where it's, my initial slide, I think it was slide 21 or 22, where it describes how a participant can appeal an adverse benefit determination. On that list, it includes a delay in services. It includes where services are delayed. So if there's a significant delay in processing the request for a home modification, you might try asking, just like writing a letter demanding a grievance based on the delay of a service. Or you can file, it's not a grievance, it'd be a complaint with the managed care plan asking them, what happened to my grievance? The plans are required to respond to those within 30 days. And the Office of Long-Term Living, which supervises the plan, tracks those complaints. And so the more they hear about outrageous delays in home modifications, the more likely that they will try and intervene. They will work with the plans to do something about it.
Okay, and is that a better route than getting a supervisor involved then?
We're still figuring this out and trying different strategies. I would say, you can always try escalating it to a supervisor as well.
Yes.
But these are just other approaches you can take in addition to that. And I don't know, Pam, what you guys have seen over at CLS with these home modifications, if you have any other additional insight.
The only thing I would add, I wonder if you think that a complaint to the Office of Long-Term Living's participant complaint line or helpline would be helpful in these situations to sort of knock things loose. I haven't had a lot of experience making complaints there, so I'm not sure how effective that is. I'm wondering what you think.
Yeah, that's another option as well. So you can call the managed care plan and ask to submit a formal complaint to them. But the Office of Long-Term Living also has their own participant hotline, which participants can contact to file complaints. And either way, it gets tracked by the Office of Long-Term Living.
Mm-hmm.
Good, thanks so much. Thank you.
Thanks, Loretta. You really raised a critical issue that's been a problem, even that predates, quite frankly, community health choices with home mods, but I think we continue. And also, just to state around this discussion around the letter for medical necessity, and that's before while we're getting Michelle Ramp ready, and then we're going to be calling on Melanie Aquilino. To say that the plans are going out now and doing reevaluations, and we are hearing more and more folks that are getting their services reduced. And so this is critical that they appeal these decisions and not just to accept what they're being told by the plan if they really think they need the help that's being lost. So I can't emphasize that enough. So Michelle, did you want to ask your question?
Hi, good afternoon. Quick question. When benefits are terminated, there was a discussion about appealing within 10 days to keep benefits in place. I guess my question is, who pays for those services if the appeal is denied? Is the consumer responsible for any services they received while the appeal was pending?
So there's, I guess, a question on both sides. The service, are you thinking about services or Medicaid eligibility?
I'm just looking back at my notes and it said appeal by 10 days if you want to keep services in place while the appeal is pending. And so I guess I'm just concerned if someone's receiving services while the appeal is pending and that appeal is denied, then who's responsible for paying for those services?
I think on the services side, I have that there wouldn't be any. I mean, the plan would pay for them. They're obligated to continue to pay for them, and they're for as long as, until another decision is made as a result of an appeal. And in that situation where we're talking about services provided by CHC, there's no mechanism I know of to make a participant pay that back.
I
Okay.
agree. I don't know of any way that the insurance company would be able to like claw that back from the
Well, I was just
participant.
concerned because a person at that point's reduced to $8,000 in order to qualify. So if they get hit with, a bill for reimbursement or something, I just was curious how that worked.
Yeah.
Well, thank you.
Yeah, thanks, Michelle. That should not happen. And if for some reason it does, you should definitely contact us at Carrie, because that should not happen. So we're going to call on Melanie Aquilino next. And then after Melody asks her question, we're going to follow by Maria Polzetti. So go ahead, Melody, could you unmute yourself and ask your question? It still looks like you're muted, Melody. Can we go? No, go ahead.
I wanted to ask about the question as far as the statement made when services have been reduced and a grievance is requested within 10 days of the notification date. You also said that it would be the 10 days or to the effective date, whichever is later. And I was just wanting to clarify that.
Sure. Thank you for your question, Melody. So if you look at the denial notice, it'll have like the date at the top, that's the mail date. And then I believe the template has some sort of language where it'll say this decision will be effective on, or this decision is effective as of X date. So the federal regulations give the guarantee continuing benefits when they have either 10 days from the mail date or they have until the effective date of the decision, whichever one is later. So if 10 days is, if 10 days is a shorter time period than the effective date, the effective date would be the latest date they could request the grievance and get continuing benefits. Does that answer your question?
Yes, thank you.
Okay.
Okay, thank you, Melody. We're going to go to Maria Polzetti next, and we have a few minutes left. If there's any last questions, type them in, and then there's a few points we'd like to make on wrap up. But go ahead, Maria.
Hi, can you hear me?
Yes.
So my question was about the external review process. I understand it can happen simultaneously with the request for the fair hearing, but I'm wondering whether you think there is sort of like any benefit to doing the external review process, like if there's any added benefit to doing it, or if we should just pursue fair hearing and essentially present the same type of documentation at a fair hearing that we might have presented to the external review.
I think there's absolutely value to pursuing an external review because it's an outside physician doing a paper review of the file. So it's a person who's outside of the insurance company reviewing their decision. I've seen a large number of cases where the external reviewer, upon reviewing the decision, overturned it, or and particularly if the participant is able to provide additional documentation during the external review. Yes, it can be it can be a way of getting the decision overturned with, frankly, a lot less work involved than going all the way through with the fair hearing. Sometimes the external review, because it's the external reviewer is a physician, they may be more receptive or more aware of some of the medical nuances in these medical necessity decisions than an administrative law judge would. So it can absolutely be worthwhile. And like I said, if the external review comes back in the participant's favor, then that they've just saved them the trouble of going through with the fair hearing. The flip side of that and the risk, I should mention, is that sometimes if the external review comes back and it's unfavorable, the plan can use that at the fair hearing and say, look, there's even this independent doctor who agrees with us that it's not medically necessary. So you may have to push back on the external review decision if the plan decides to use it. Pam Wallace, do you have any thoughts on your experience with the external review process?
We just haven't had a lot of experience yet with it. I know that we recently had a case in our office where an attorney did have some success with external review.
So I think with that wraps up our questions, and David's going to put a quick poll up, and there's, I wanted to, again, make a couple wrap-up points, but there's a question I think that may be helpful to keep in the archive and answer now, if you're able. One issue that we encounter are people, this process takes so long, the application process, that sometimes applicants start out and they might be slightly over, so they're, but they spend their money down while their application's being considered. Can you talk about that situation in terms of that being appealable for the financial eligibility?
Sure. So first of all, it takes a little while to get to the financial eligibility determination part of it. So it's possible that someone in the course of applying, going through the clinical eligibility determination process, will go ahead and spend down. And if so, by the time they get to the point, a month, 6 weeks, maybe 2 months on, where they're submitting their financial verification, could be that they have spent down, and if so, they'll be found eligible. If they're not eligible at that point, and they get an unfavorable decision, they can appeal, and then at any point up to and including at the fair hearing, or frankly, if they enter into a stipulation, even later than that, they can provide verification showing that their resources are now under the resource limit, and they can be found eligible at that point in time. And since home and community-based services can only be provided sort of going forward prospectively, there's no problem about whether they were eligible in the past in most cases. They're looking for services to begin. And so once they're found eligible, they can be, enrolled in the CHC program and start getting services.
Okay, that's very helpful. Well, again, I want to thank you both. I want to ask folks, as we're concluded this series now on the enrollment and redetermination process. Again, they're all there's archives available to as resources. One reason we started this series is because the redetermination process often leaves folks getting cut off from services, even for a temporary amount of time, can be devastating. And right now, during the COVID public health emergency, there is a waiver in place that does not allow people to lose their services. So once this redetermination process begins again, we're not quite sure how the backlog is. The current emergency goes through January 20th of 2021. However, the state could decide really at any time to begin this again. And we really need to be vigilant to help folks so they don't lose their services. So today's presentation and the others hopefully give you the resources needed to not only successfully apply, but also keep services. And we're all here to help. So again, slides will be sent. Any other suggestions you have for future webinars, please send our way. And again, I want to thank both Pam's and both of your agencies for your hard work and advocacy. And thanks again to everyone who's participated today, and everyone stay well. Thanks again. Bye-bye.